Hello everyone. Today we are going to discuss the law subject, that is labor law, and under this labor law subject we are going to discuss Industrial Dispute Act 1947. So today we are going to discuss the introductory part. What is the scope, object of this act, and what are the what are the terms which are used in this Industrial Dispute Act, right? So let us start with the introduction of this Industrial Dispute Act 1947. The Industrial Dispute Act 1947 talks about disputes that occur in an industry, right? So it is basically a dispute which occurs in an industry. Dispute may arise between two or more industries, so it may be between two or more industries. It also makes provision for the investigation and settlement of disputes. So it makes provision for the investigation and settlement of the dispute that may hamper the peace of the industry. So whatever dispute that may arise in the industry, so in order to just resolve and investigate and settle that dispute, for that this Industrial Dispute Act makes provision, right? It ensures harmony and cordial relationship between the employer and employees. So it basically ensures cordial relationship and harmony between the employer and employees. So it also provides various committee and offices for resolution of such disputes. So it talks about committees and offices which help in order to resolve the disputes between the employer and employees. The act provides self-contained code to compel the parties to resort to industrial arbitration for the resolution of disputes. It talks about self-contained code. So yeah, it provides the procedures, right, with the help of arbitration all the resolves are taken care of. It provides statutory norm besides helping the maintaining of cordial relation among the employer and employees, reflecting socio-economic justice, right? So it says it also provides statutory norms. So apart from the it also provides statutory norms beside helping in maintaining. So it provides a statutory norm. It provides some norms and procedure with the help of all the disputes in the industries are taken care of, right, between the employer and employees. So after this we are going to see some of the issues which will help us in order to understand what exactly Industrial Dispute Act is. So what are the so here we are going to discuss the objective of the Industrial Dispute Act. The objective of the Industrial Dispute Act 1947 is to secure industrial peace and harmony. It talks about the industrial peace and harmony by providing machinery. It provides machinery and procedure for the investigation and settlement of industrial dispute, right? So it provides procedure where the investigation, with the help of investigation and settlement, all the disputes are taken care of by negotiation. This act deals with the retrenchment process of employees. It also deals with the retrenchment of the employees, procedure for layoff, what is the procedure for layoff procedure, and rules for strike and lockouts of the company, right? So whatever the dispute, what are the concerns which may happen in the industry, which may hamper the smooth functioning of the industry, so all those disputes are taken care of, are resolved with the help of this Industrial Dispute Act. So now let's move further. It is what is the definition of industry and industrial dispute under Industrial Dispute Act? So here we are going to see the definition of industrial dispute. As per section 2J, industrial dispute, what is industry? As per section 2J, industry means any systematic activity carried on by, so it is talks about any systematic activity which is being carried on by cooperation between employer and employer and his workmen, right, for the production, supply, distribution of goods, for the production, supply, distribution of goods and services with the view of satisfying human wants or needs. So wherever they use, wherever we can see production, manufacturing, production of anything, any material, any services, so that may be called industry, right? So now let's move further. According to section 2A, where an employer discharges, dismisses, retrenches, or otherwise terminates the service of an individual worker, it terminates otherwise. It means which is not as per the contract. Whatever thing has been decided between the employer and employee, if it is not according to that, and if the employee has been where the employee has been terminated, right? So and there, if there is any so that dispute, any dispute or difference between that workman and his employer connected with or arising out of such arising out of that discharge, dismissal, retrenchment, termination shall be deemed to be an industrial dispute, notwithstanding that no other workman nor any union of workmen is party to the dispute, right? So irrespective, it is not concerning that no workman or nor any union of workmen is party to the dispute, right? So it primarily it talks about uh, it is arising out of discharge, right? So any dispute which is arising out of such discharge, dismissal, retrenchment, termination, that thing will be termed as industrial dispute, right? Now industrial dispute have adverse effect on the industrial production. So if there is any industrial disputes, obviously it is going to affect the proper functioning of the industry. So that the production efficiency, cost quality, human satisfaction, discipline, technological, economical, progress, and finally on the welfare of the society. So in this way, if there is any disputes, obviously the industry will not be able to function properly. A discontent labor force, right? If the labor force is not happy, is discontent, uh, so nursing in its heart mute grievances. If there is any grievance which has not been taken care of, any resentment, right, cannot be that labor cannot be efficient and will not possess a high degree of industrial morale, right? Okay. Now, hence the Industrial Dispute Act 1947 was passed as a preventive and curative measure. So it was passed in order to make sure that all the disputes under this may be taken care of. Okay. Now let's move further. What are the types of industrial dispute? There are four types of industrial dispute. Interest dispute. Interest dispute arise out of deadlocks in negotiation for collective bargaining. So it is basically primarily for the collective bargaining, right? Uh, which So interest dispute arise out of deadlocks. So it arises because of the deadlocks and a standoff in negotiation for collective bargaining. So if there is going to be any negotiation for any collective bargaining, and if there is any deadlock, so that may be called that is called industrial dispute. Grievance dispute pertains to discipline, wages, working time. So it basically it is pertaining to any discipline, wages, and any concern, any dispute regarding wages, working time, promotion, right of supervisor, etc. It is called it is also called interpretation dispute, right? And if there is anything which is pertaining to wages, working time, promotion, rights of supervisors, that will be grievance dispute. Unfair labor practices are those arising out of right to organize. So these are the which arise out of right to organize, act of violence. If there is any act of violence, failure to implement and award, discriminatory treatment, illegal strikes and lockouts, so these all will be called unfair labor practices. Recognition disputes are over the rights of a trade union. So these are the disputes which are over a right of trade union, so which is concerning the trade union to represent class or category of workers. So it is concerning represent I mean it is a rights of trade union to represent class or category of workers, right? So recognition dispute are disputes over the rights of a trade union. So it's a dispute over the rights of a trade union, okay, to represent class or category of workers. Okay. Now let's move further. What are the dispute settlement authorities under the act and their powers and duties? So it is the following authorities are for investigation and settlement of industrial disputes. So here we are going to see what are the authorities. It is works committee. Section 3 that talks about works committee. So the works committee is a committee consisting of representatives of employers and workmen. So it is a representative for employers and workmen. The works committee is a forum for explaining the difficulties of all parties. So it is a forum where difficulties of all the parties are taken care of. They are just all the parties, they get a proper forum where they can simply just convey their concern, where their disputes can be taken care of. Main objective of the works committee is to solve the problem arising in the day-to-day working of a concern and to secure industrial harmony. So basically whatever day-to-day problems arising in a day-to-day working, so that is taken care of, right, with this works committee. The function of the working committee is to ascertain the grievances of the employees and to arrive at some agreement. So the basic function is to ascertain the grievances of the employees, right, and to come to an agreement, right? The committee is formed by journal or special order by appropriate government in an industrial establishment. So this committee is formed by journal special order by the appropriate government in any industrial establishment in which 100 or more workmen are employed. So the condition is there should be 100 or more workmen are employed or have been employed on any day in preceding 12 months. Preceding 12, so the condition preceding 12 months, 100 or more employees. It consists of the representative of employers. So it consists of the representation is from the employers and workmen engaged in the establishment. It shall be the duty of working committee to promote measures for securing and preserving amity and good relation between the employers and workmen. So basically, the primary duty is to preserve amity, friendly relation, and good relation between the employers and workmen. And let's see what does section 4 say. The section 4, it says, for promoting and settlement of industrial dispute, appropriate government the appropriate government here may, by notification, the official, so that is the official gazette, appoint such number of conciliation officers. So there may be such number of conciliation officers, which may be appropriate as per the appropriate government. The main objective of appointing conciliation officer is to create congenial atmosphere, the friendly atmosphere within the industry, and reconcile the dispute of the workers. So if there is any dispute, so in order to take care of that dispute, this conciliation officer is usually appointed by the appropriate government, right? Reconcile the dispute of the workers and the employers. He may be appointed for a specified area. So in that conciliation officer may be appointed for a specified area or specified industries in specified area, or for one or more specified industries. So it may be for one or more specified industries, either permanently or for a limited period. Okay. The duty of the conciliation officer is not judicial but administrative. The duty is not judicial, but it is purely of administrative. He has to hold conciliation proceeding, investigate the dispute. So he basically holds proceedings. He investigate the dispute and do all things as he thinks fit, for the purpose of inducing the parties to arrive at a fair settlement of the dispute. So basically, bringing negotiation, just bringing all the parties at a common point where the dispute can be resolved, and could be the dispute could be taken care of, and the proper functioning of the industry can be achieved. The conciliation officer is entitled to enter an establishment to which the dispute relates after reasonable notice, and also to call for and inspect any document which he considers relevant, right? So he can enter into an establishment where the dispute relates after reasonable notice, and call for, and he may also inspect any of the documents regarding the same. Okay, and now after that, he has to send a report and memorandum of settlement to appropriate government. So, and he has to send that report to the appropriate government, right? And the report should be submitted within 14 days. Okay, days of the commencement of conciliation proceeding, or shorter period, as may be prescribed by the Board of Conciliations. So let us see what are the members of the Board of Conciliations, right? The appropriate government may, by notification in the official gazette, constitute it is again by the appropriate government, which will be issued in the which will be mentioned in the notification in the official gazette, constitute a board of conciliation for settlement of industrial disputes. So this appropriate government is going to constitute board of conciliation for the settlement of industrial dispute. The board shall consist of a chairman. So there will be chairman and two or four other members in equal number representing the parties to the dispute. So there will be chairman and two or more four other members in equal numbers representing the parties to the dispute as appropriate government thinks fit. So it is the discretion of the appropriate government, right? The chairman shall be an independent person. The chairman should be an independent person. Person is independent for the purpose of appointment to a board, court, or tribunal if he is unconnected with the dispute. So that chairman should be unconnected with the dispute with any industry directly affected by such dispute. So he should be unconnected, right? Where the appropriate government is of the opinion that any industrial dispute exists, where the appropriate government thinks that there is in any industry there exists any industrial dispute, it may refer by order in writing. So it may by order in writing to the Board of Conciliation for setting industrial dispute. So it may order for the settlement of the dispute by the Board of Conciliation. The Board of Conciliation has to bring about a settlement of dispute. So it has to settle the dispute. He has to send a report and a memorandum of settlement to appropriate government. It needs to be submitted to appropriate government. He has to send a full report to the appropriate government. He has to send obviously the full report to the appropriate government for setting the for the steps taken by the board. So all the steps which has been taken by the board in case board in case no settlement is arrived at. In case if there is no settlement, so whatever the things have been done there, so the report has to be sent to the appropriate government. The board has to submit its reports within 2 months. So the time period is within 2 months of which the dispute was referred to. So within the period what the appropriate government may think fit. The report of the board shall be in writing and shall be signed by all the members of the board. So all the report is supposed to be signed by the all the member boards. Okay, now let's move further. Court of inquiry. So now section talks about court of inquiry. The appropriate government may by notification in the official gazette. Again, it is going to be set up by appropriate government that will be in the official gazette, constitute a court of inquiry into any matter appearing to be connected. So if there is any matter which is connected with or relevant to the settlement of industrial dispute, having an independent, so they again they are supposed to be independent person or of such independent person as the appropriate government may think fit, right? So again, it is the independent person. The court consists of 2 or more members. Again, there will be 2 or more members, one of whom shall be appointed by the chairman. So here the chairman is going to appoint is going to appoint one member from those 2 or more members, right? The court has the court consists of 2 or more members, one of whom, so out of those members, one will be appointed by the chairman. Within a period of 6 months, the court has to send a report thereon to the appropriate government from the commencement of its inquiry. So within 6 months time, it has to just it has to resolve that issue, and after the court of inquiry, the report is supposed to be sent to the appropriate government. The period is not mandatory. It may extend. So it depends. Like so it depends. After giving proper reasonings, it may be even just the 6 months of time may also increase. It has the same power as are vested in civil court under the Code of Civil Procedure, right, in the following matters. So it has got this, and the court of inquiry has got the court of inquiry has got the powers of the civil procedure code, okay, 1908. So what are the powers? Let us see. Enforcing the attendance of any person and examining him on oath. So it may be summoned and may be examined on oath. Compelling the production of document and material. So it may be it may ask the person to it may ask for the production of documents and material objects. Issue commission for the examination of witness, right, in respect of such other matters as may be prescribed. The report of the court must be signed by all the members. So obviously it is going to be signed by all the members. The member can submit a note of dissent. So the people are not agreeing, so they may also submit a note of dissent, right? So may disagree also. The report together with the dissenting note must be published by the appropriate government within 30 days. So that dissent report has to be dissenting note has to be published within 30 days of its report. A court of inquiry has no power to improve any settlement upon the parties. So court of inquiry cannot improve any settlement, right? Okay. So let's see what does section 7 say. It says labor code. The appropriate authority again may by notification. So whatever things are going to be done, it will be by notification in the official gazette, okay. Constitute one or more labor court for the adjudication of industrial disputes. So one or more labor court may be constituted for the adjudication of industrial dispute relating to any matter specified in the second schedule. So there is a second schedule. So all the matters which are mentioned over there, so according to that, this labor court may be constituted. So a labor court consists of one person only to be appointed by appropriate government. So there is going to be only one person. The function of the labor court is to hold its proceeding expeditiously. It means speedily, in a speedy manner, and submit its award as the proceeding concludes. Okay. So after this, it has to submit the award also. A person shall be, what are the qualities, right? A person shall be the qualifications, sorry. A person shall be presiding officer of a labor court unless he is or has been a judge of the high court. So he is supposed to be judge of the high court. He has for a period of not less than 3 years been a district judge or an additional district judge. For at least, he should be judge of additional district judge for at least 3 years. He has held any judicial office in India for not less than 7 years. So if he is a judicial officer lower than that, so he should be for at least 7 years. He has been the presiding officer of a labor court constituted under any provincial act or state act for not less than 5 years. So it should be, if he is an officer of the labor court, presiding officer labor court, so that should be for at least 5 years. He must be independent person and must not have attained age of 65 years. So the age limit is 65 years. Now after this labor tribunal, so let's see what does section 7A says. The appropriate government may by notification of official gazette, obviously it is again the same thing. Appropriate government official gazette constitute one or more industrial tribunal. So again, one or more industrial tribunal may be set up for adjudication of industrial dispute, any industrial dispute, as we have discussed. The tribunal shall consist of one person to be appointed. So the tribunal shall consist of person which is going to be appointed by the appropriate government. The appropriate government may appoint two person as assessors. So the appropriate government may appoint two persons as an assessor to advise the tribunals, right? So it may appoint two persons as assessors, right? To advise. So their role will be to advise the tribunal. Okay, so their role is going to appoint the tribunal. The person shall not be qualified unless, so these are the qualifications, that unless he is judge of the high court. So he should be a judge of the high court. He has for a period not less than 3 years been district judge or additional district judge. So it should be district judge or additional district judge at least for 3 years. The appropriate government may, if it so thinks fit, may appoint two person as an assessor to advise the tribunal in the proceeding before, right? So, and also the appropriate government may, if so thinks fit, may appoint two persons as assessors. So it may appoint two persons as assessors to advise the tribunal in the proceeding before it. The function of the tribunal are very much like those of the body discharging judicial functions. So here the functions will be like discharging judicial functions. Okay, although it is not a code, although it is not, so it is not code, but functions will be judicial functions. Its power is different from that of civil court. So it is going to be different from civil court. The proceeding before an industrial tribunal are and the proceedings before an industrial tribunal are quasi judicial in nature with all attributes of court of justice. So it is quasi judicial in nature, right? But it will have the attributes of court of justice. Okay, now let's move further. Now we are going to talk about national tribunals. Now it is as per section 7B. Earlier was the labor tribunal, which was as per section 7A. It is section 7B, which talks about national tribunals. The central government may, by notification in the official gazette, constitute one or more national industrial tribunal for the adjudication of industrial dispute. So the central government here, which authority? It is the central government which can appoint, which can constitute national tribunal, right? Industrial tribunal for the adjudication of industrial dispute. National industrial tribunals are national industrial tribunal are tribunals which these are the tribunals where the question of national importance, where the cases concerning question of national importance, if they are of such a nature that industrial establishment situated in more than one state, right? So where the this industrial establishment is situated in more than one state, are likely to be interested in or affected by such industrial dispute. So if there is a dispute within one or two states, and it is going to be affected by such industrial dispute, so for that particular concern, national tribunal is going to be that is generally that is generally constituted by the central government, right? So it consists of one person only to be appointed by central government. So there is only one person, right, which is going to be appointed by the central government, right? So the basic purpose of national tribunals are involved only in national tribunals. They are involved only in case of question of national importance. If there is any question of national importance which is which has got the character of national importance, right, and there is any industrial dispute between any industrial dispute, right, and that industrial establishment is situated in more than one state, are likely to be interested or are affected by such industrial dispute. Okay, and the so let us see the qualifications of the this national tribunal. So the person shall not be qualified for appointment as the presiding officer unless he is or has been a judge of high court. So he is supposed to be judge of high court, right? Besides this, the central government may, if it thinks fit, appoint two persons as assessors to advise the national tribunal in proceeding before it. So if the central government, if it thinks fit, it may appoint two persons as assessors to advise the national tribunal in the proceeding, right? Now after this, let's see what do we mean by strike. As per section 2Q, the strike means of as per section 2Q of Industrial Dispute Act, strike means a cessation of work by a body of persons. It means cessation of, it's a cessation of work by body of persons employed in any industry, acting in combination or concerted refusal under a common understanding. So it is a refusal under under a common understanding. There is a refusal that they are not going to continue the work. They are not going to continue the work in the industry of any number of persons who are or have been so employed. So it may be by any number of persons who are or have been so employed to continue to work or accept employment, to continue to work. So there is a refusal to continue to work or to accept employment. Mere stoppage of work does not come within the meaning. So if there is mere stoppage of work, that will not be considered strike, right? That does not come within the meaning of strike unless it can be shown that such stoppage of work was concerted action for the info. So unless it is shown that such stoppage of work was a concerted action for enforcement of industrial demand. So if there is any industrial demand, they are just demanding something. So until there is no demand, so till then it will not be considered strike, right? So there has to be some industrial demand. So let us see what is lockout. As per section 2L, lockout means the temporary closing of place of employment or the suspension of work or the refusal by employer. So this is from the side of employer, right? This strike is from the side of employee, and the lockout is from the side of employer to continue to employ any number of persons employed by him. Lockout is the antithesis of strike, right? It is a weapon of the employer while the strike is that of the worker. So lockout, it is the weapon of the employer, and strike is the it is the weapon of the employer. Lockout is the weapon of the employer, right? While the strike is that of the worker. Just as a strike is weapon in the hands of the worker for enforcing the industrial demand, lockout is a weapon available to employer to force employees to see his points of view and to accept his demand. So right, so both the things are given. If there isn't any demand from the side of the employee, so that will be done with the help of strike. If there is any demand from the side of employer, so that will be done with the help of lockout, right? Now the Industrial Dispute Act does not intend to take away these rights. So Industrial Dispute Act does not take away both the rights, right? However, the right of the strike and lockout have been restricted to achieve the purpose of this act. However, the right of strike and lockout have been, so basically the law, it basically decides what strikes are legal, what strikes are illegal, and what lockouts are legal and what lockouts are illegal, right? Namely peaceful investigation, settlement of industrial dispute. So it talks about the industrial dispute. It talks about the peaceful investigation and settlement of the industrial dispute. So there is a peaceful investigation, right? Okay, and let us see, there is an important case. It is Journal Labor Union versus B.V. Chavan and others. The Supreme Court of India held that imposing and continuing a lockdown deemed to be illegal under the Act is unfair labor practices. It means imposing and continuing a lockdown which is deemed to be illegal. If any lockdown which is not legal, which is illegal, right, which is not legal, which is illegal under the Act, will be deemed an unfair labor practice, right? So with this we have come to the end of this introduction part, and I've made this in several parts. So the next part we will cover in the next lecture. So thank you very much.